As expected and reported, former President Donald Trump reported to Washington, D.C. today to a federal courthouse where he pled not guilty to 4 different counts brought in a new indictment by Special Prosecutor Jack Smith. This is the third such indictment that's been handed down against the former president this year, one in New York, one in Miami, and now one in Washington, D.C. These particular charges relate to events that happened on, before, or around January the 6th. So let's get into an analysis of what he's been charged with and also how strong these charges actually are. Give me 1 second, folks. We're going to get into all of that in just one moment. My name is Brian Trippett. I am your front porch conservative. Step on up to my electronic front porch and let's talk. Story of the day. That being former President Trump reporting to a courthouse in Washington, D.C. to make his plea on the new charges that have been brought by Special Prosecutor Jack Smith. There's been all kinds of commentary that's broken loose from about 3 o'clock in the afternoon, even up until now, well into the night. But I want to focus on some basic questions to help try and understand what this is that he's been charged with and just how strong these charges actually are, which, for the record, many people on the legal right of the spectrum believe that these charges aren't that strong and really don't bear up under scrutiny. And I found a really fantastic article that summarizes all the objections and I think lays it out in such a way that makes it very easy to understand. So we're going to go to the Federalist. Article written by Will Scharf. Headline: 6 ways Jack Smith's latest indictment is legally flawed and politically shady. Now, I'm not going to read everything in this article as it's quite lengthy, but I'm going to try and hit the high points and do a little bit of summary and a little bit of analysis, commentary about what I think it all means. So we start to the first paragraph. Special Counsel Jack Smith's latest indictment against President Trump seeks to criminalize political speech and taking incorrect legal advice. Americans of all political stripes should be furious and deeply concerned by the course Smith has set this country on. I have reviewed the new Trump indictment closely, and sadly, it is exactly what we have come to expect from Smith's team: a highly political document riddled with legal and factual infirmities. This indictment should never have been brought to a grand jury in the first place. Moreover, its timing, particularly in light of Smith's statements and actions in the Trump document case, is so highly suspect that it casts a political pall over the whole case. Now, as to the indictment itself, what has Donald Trump been charged with? Smith's indictment contains 4 counts against Trump. The first, brought under 18 U.S.C. Section 371, alleges that Trump conspired to defraud the United States, quote, by using knowingly false claims of election fraud to obstruct federal government function by which those results are collected, counted, and certified. The second and third counts allege conspiracy to obstruct an official proceeding and the actual or attempted obstruction of an official proceeding, both in violation of subsections of 18 U.S.C. Section 1512. The fourth count alleges that Trump committed, quote, a conspiracy against rights by knowingly conspiring to deprive Americans of their right to vote and have their votes counted in violation of 18 U.S.C. Section 241. Having read the indictment, having followed January 6 related cases closely, having read extensive news coverage, and having spoken to others with experience in the areas of the law, I do not believe that any of these charges can fairly be proven beyond a reasonable doubt in front of a. I would expect that were this the case to reach the Supreme Court, The court would reject Smith's theories of liability on all or at least some of these counts, as it did unanimously with the prosecution of former Virginia Governor Bob McDonnell. Smith and his team did a real disservice to the cause of justice by bringing this indictment. Number 1. Trump's state of mind. In the Trump documents case, we already have seen how thorny issues of intent can be. There, many of us have argued that in light of the president's rights and responsibility under the Presidential Records Act, it is essentially impossible for Jack Smith to prove that Trump knowingly violated the Espionage Act subsection charge. Here, we have a similar issue. For all 4 of these charges, Smith needs to prove beyond a reasonable doubt that Trump knew his claims about election integrity were false and that he knew the legal theories his team advanced were not viable. Okay, let's stop and analyze objection number 1. Will Scharf is absolutely right. Look, I'm not a lawyer, but common sense tells me that the only way that Jack Smith and his team of jackbooted prosecutors can make this thing work in a court of law is they have to show a jury beyond an absolute reasonable doubt that Donald Trump knew he was lying the whole time. Every time he said that the election was rigged, every time he said stolen election, every time he said there were problems with the votes, every time, everything else, they have to get into his mind and be able to say, yep, he was lying, and daggone it, he knew it. Which is a point, by the way, that other people are picking up on. Let me show you something real fast. This is a tweet from Robert Barnes. This below is a complete idiot pretending to be a lawyer, referencing someone else. To be clear, it is a complete defense for Trump if he believed he won in an honest constitutional election. Hint, he did. The prosecutor must prove Trump lied and knew he lied, or they have no case. And in Barnes's opinion, they have no case. Okay. As I say, you've got to be able to show Trump knew he was lying the whole daggone time. Otherwise, this case blows up. And I have a question for Jack Smith. How are you going to prove that? Let's assume for a moment you can even have snippets of conversations with various people that Trump talked to from the day after the election up to the day of January the 6th. You're going to tell me that those conversations completely and accurately reflect Trump's state of mind? That doesn't even begin to make sense. So yeah, Trump's state of mind is problem number 1 for the prosecution in all of this. Okay, but let's go back to the article. I want to move on and show some other deficiencies with these charges. Okay, so we'll move down to item number 2. Second problem, in the opinion of Will Scharf, the criminalization of political speech. Others have made this point publicly already, so I won't belabor it. To put simply, Jack Smith's theory of the case necessarily requires criminalizing political speech. This is core protected activity under the First Amendment, and the legal implications are truly scary for our democracy. Is any public challenge to a certified federal election a criminal act? In Jack Smith's telling, the answer is probably yes. At what point do election challenges become criminal? Based on Jack Smith's theory of the case, the answer to that is entirely unclear, meaning that the very fact that this indictment was brought may have a deeply chilling effect on protected speech in years to come. Hillary Clinton, Stephanie Abrams, and many, many others have claimed for years that their elections were stolen from them. Abrams continued her efforts to challenge her defeat to Brian Kemp long after the results were clear. Andrew Jackson claimed John Quincy Adams cheated him out of the election of 1824. After the 2000, 2004, and 2016 elections, Democrats attempted to interfere with the electoral count process. Did those actions constitute a conspiracy against rights under Section 241? Under Smith's theory of the case, I think the answer is unclear, but possible. And I'll tell you what, Will Scharf brings up an absolutely valid point. It doesn't matter which side of this argument you're on, Democrat, Republican, liberal, conservative, libertarian, whatever. Do you not realize the can of worms that's being opened up here? If Smith goes forward with this theory of his, that even challenging the results of an election could be considered criminal, then not only could Donald Trump be brought up on charges and possibly found guilty, then if I'm Jack Smith, I better start bringing up charges against Hillary, Stephanie Abrams, Barbara Boxer. I mean, Lord have mercy, you could list a whole slew of charges against a whole slew of people, and a lot of them would be Democrats. Since when is exercising the right to free speech against the law, particularly if it is a challenge to what one individual or individuals feel is an election that was not conducted in a constitutionally correct manner? And that is at the heart of Trump's defense in all this, which, by the way, his attorney, who was speaking on his behalf today, John Laro, was giving an interview to NPR, and I want to show you part of what was said by him. Let me get into this article. He's asked by NPR, I want to talk legal strategy. Could you give us a summary of your legal defense to these criminal charges? Laro says, quote, it's no big surprise when you look at this indictment, it doesn't really say much other than Donald Trump was exercising his right to talk about the issues and advocate politically for his belief that the election was stolen and was improperly run. He got advice from counsel, very, very wise and learned counsel, on a variety of constitutional legal issues, so it's a straightforward defense that he had every right to advocate for a position that he believed in and his supporters believed in. And this is the first time in the history of the United States where a sitting administration is criminalizing speech against a prior administration. It's really quite unprecedented, and it really will politicize the criminal justice system, which is terrible to see. And Trump's attorney is not wrong. Donald Trump, or anyone else for that matter, doesn't matter who it is, has the right to exercise their right to freedom of speech under the First Amendment to challenge the results of an election. Jack Smith's legal opinion be damned. Donald Trump, in that respect, did absolutely nothing wrong. All he did was say, hey, I think this election was improperly run. Hey, I think this thing has fraudulent votes. Hey, I think the Congress ought to take a look at this. But to hear Jack Smith tell it, oh, no, you can't do that. That's a criminal activity. So that's problem number 2. Let's go back to that article from the Federalist, and we'll go to item number 3 in Will Scharf's objection. Proving Trump's specific intent. Section 241 is a statute. Now, let me back up a second. This goes to count number 4, the conspiracy against rights. Okay. Section 241 is a statute that was originally designed to deal with violence against black voters by the KKK and other similar efforts to deprive people of their constitutional rights. Jack Smith's use of it here is outrageous on its face, designed to inflame perhaps more than anything else. But there are also serious legal issues that Smith and his team seem to be willing to ignore in terms of the statute's applicability to the facts alleged. Going a little further into this objection, in United States v. Guest, the Supreme Court grappled with the constitutionality of this statute, facing an argument that it was unconstitutionally vague and overbroad. The Supreme Court ultimately held that the statute was constitutional, but only because of the heightened intent requirements that follow from it being a conspiracy statute. In the Supreme Court's words, a specific intent to interfere with the federal right at issue must be proved, and on the part of the alleged conspirators. Only because of that specific intent requirement was the prosecution in that case allowable, and was the statute itself deemed to pass constitutional muster. In simple language, ladies and gentlemen, and this goes back to a point that Will Scharf made earlier, the prosecution has to be able to prove to a jury that it was absolutely Donald Trump's intent to conspire against individuals to deprive them of their right to vote. Now remember what this Section 241 is all about. This goes back to the days post-Civil War when the KKK was trying to deprive black voters in the South of going to the polls and exercising their right of franchise. The Supreme Court said, all right, the law is a little bit vague, but if you can prove that that was criminal intent, that that's exactly what they were going to do, then okay, statute stands. Again, a question for Jack Smith and his legal team. You mean to tell me that you can prove that Donald Trump had criminal intent to deprive people of their votes? In what universe does that even begin to make sense? This is crazy. And Will Scharf is absolutely right. There's no way Jack Smith's going to be able to prove this. You're using a law that was supposed to apply to the KKK to use it against Donald Trump? Good God. This man, I tell you what, Jack Smith and his legal team ought to go back to law school. Or at a minimum, they ought to have their law licenses revoked because these people are a bunch of idiots. Okay, let's move to point number 4. Proving a fraud conspiracy. Section 371, and this deals with the question of conspiracy to defraud, or the count of conspiracy to defraud, is a statute that criminalizes defrauding the federal government or interfering in lawful function of government. Its origins are in the tax fraud context, and it was originally cabined closely to property fraud against the federal government. Even after the statute was expanded, though, the Supreme Court urged caution throughout the statute's history that a conspiracy charge related to the obstruction of governmental functions must be premised on the use of deceit, craft, or trickery, or at least means that are dishonest, as was decided in Hammerschmidt v. U.S. Open defiance of the law, for example, cannot give rise to a 371 charge. Again, you have to be able to prove that Donald Trump was trying to do just that. There's no way to make that stick. A fraud conspiracy? And based on an old tax fraud law. Again, Smith is really stretching on this one. This is just amazing to me. Let's move on to point number 5. Objection is misapplication of the obstruction law. Let's read this a little further. Section 1512, which deals with the count of obstruction of a federal proceeding, was originally enacted as part of the Sarbanes-Oxley Act in 2002, intended to deal with the fallout from the Enron collapse investigations. Subsection C, under which Trump has been charged, deals primarily with destroying evidence in advance of a judicial proceeding or legislative inquiries, but it also contains a catch-all provision that criminalizes corruptly obstructing an official proceeding. The Biden DOJ has used this catch-all provision controversially to prosecute January 6 defendants, and 2 of the counts in this new indictment track this theory, that Trump's activities and statements constituted an obstruction of a official proceeding, namely the electoral count process. Okay, let's stop and think about that for a second. Trump objects to the electors being accepted and voted upon and approved by the whole Congress on the grounds that the electors shouldn't be there, on the grounds that there's fraud or election chicanery in the states where these electors come from. Under Jack Smith's very stretched out legal theory, no, you can't do that because that's obstructing a government proceeding. Well, how are you going to get a redress of grievance unless you object to the process? That's denial of First Amendment protection of redress of grievance, petitioning your government for a redress of grievance. That's crazy. So that doesn't even begin to make any sense. But let's move to the last objection listed in this article from the Federalist. And this one's more political than it is legal. Perfectly timing the trial for election season. As he did with his original indictment in the documents, Jack Smith accompanied his announcement of charges yesterday with a cynical call for a, quote, speedy trial. More than anything else, Smith's insistence that these cases that he is bringing should be tried at the height of a presidential election adds fuel to the fire of Trump's expressed view that the special counsel is waging a political campaign against him and not a valid legal investigation. Okay. The Constitution does state that there is such a thing and should be a speedy trial, but that's to the benefit of the defendant, not the prosecution. So Jack Smith's trying not only to get the case down in Miami done before the 2024 election, he's trying to get this one jam-jobbed in as well. And again, everybody can see it for what it is. And if you're wondering that what I mean by that, take a look at this. This is a tweet from Joel Pollack, the fabulous writer over at Breitbart. The more indictments Democrats file against Trump, the more they reinforce suspicions that the 2020 election was stolen because a party that believed it could win in a free and fair election would not have to abuse the courts to persecute the opposition. It looks like cheating. Folks, this new set of charges in this indictment absolutely do not stand up under scrutiny. They're not going to stand up under scrutiny. And Will Scharf at the Federalist is absolutely right. If this goes up to the Supreme Court, odds are they're going to dismiss most, if not all of this, on grounds of violation of free speech. Regardless of what you think of Donald Trump, he's got the right to exercise his First Amendment protections to his own benefit. Same as you, same as me, which, by the way, here's something that everybody ought to think about. This is focused on Donald Trump, but if the federal government, through the Department of Justice, is allowed to get this one under the door, then nobody is safe. Nobody's right to freedom of speech is guaranteed anymore, because you could object to an election. You could object to anything. And if the federal government finds that to be objectionable, then they're going to try and criminally prosecute you. So regardless of what you think of Donald Trump, you better be rooting for him, because if he loses this case, this affects you just as much as it does him. But that's what I think about it. What do you think? As we start to wrap up this video, please do me some favors as always. Number one, if you're not a subscriber to the channel, please do so. Number two, please hit the bell for notifications. I want to make sure you're always aware when new material is coming out. Number three, please leave a comment below. Number four, give me a thumbs up on the video. And number five, please share the video around. My name is Brian Trippett. I am your Front Porch Conservative, and I'll see you next time.